Hi, Erica.
Oh,
Thanks. Hi, thanks for being part of the conference. You're a lawyer, and you're the only lawyer on our faculty, so we're going to rely on you for lots of information. Can you tell us what kind of lawyer you are and what your relationship is around cancer, prostate cancer or cancer patients?
sure. So, first of all, thank you for inviting me. I'm certainly happy to collaborate and be part of the conference. So the kind of law that I am familiar with is trust and estates practice. So that's the one that has to do with wills and inheritance and, succession to inheritances and things like that. So to tell you a little bit about my background, when I first started out in my first experience with trust and estates, I was working for a boutique firm, and our normal client base was the elderly, actually, and people who had, I would say at that time what is considered upper middle class, to wealthy individuals, people who have a high asset value. And I did that for about 1 to 2 years, and then I transferred from there to a nonprofit organization. It was called the Family Center, and that's really that. It's what you would call poverty law. But what I did at that organization is that we drafted wills, and we did maybe some small estate administrations for individuals. And our criteria for taking on clients at that nonprofit, it was illness based. So we would take people that had a cancer diagnosis or an AIDS or an HIV diagnosis or a combination, as well as people that were maybe caring for kids that weren't their own. So most, if not all, of my clients at that time were diagnosed with some kind of cancer. And then after doing that for about 6 or 7 years, I am now a court attorney with the New York County Surrogates Court. So that's Manhattan. We do Manhattan Estates. It's very busy. And what I do there specifically is I run the help center. So anybody who does not have an attorney for any reason can go to the help center and obtain some assistance with their estate paperwork. So we tell them what they need to file, and if it's appropriate, we'll help them file. If it becomes contested, then they need to actually seek counsel. So I've gone from people who are, from a higher socioeconomic background to people that are low income. And at the help center, because it's a courthouse, you get people that run the full gamut. So what I do certainly applies to people, I think, in every area. And I think it's obviously something that you think of more after you get a diagnosis, for sure.
Right. So you're like the perfect person to talk to about how to make sure that things happen the way I want when I'm dead, and you're also like the perfect person for spouses and partners and children and nieces and nephews and what have you, who are genuinely concerned, like, what do you do after they lose someone to prostate cancer? How do you manage all that money, if there's any, or anything else? What do you do with the silverware?
Right.
Yeah.
Right.
So why
Yeah.
don't you sorry, go ahead.
Go ahead. I didn't mean to cut you off. Sorry.
So can you just take us step by step, I'm still alive. I want to make sure my spouse's partners, children's, nieces, nephews, and maybe, some goodwill agency or certainly Malecare, gets the $3 and change I have in my bank account. And what little I could pull in my tiny apartment. What does a guy do around a will to start?
Sure. So I think that when a person really, really needs a will, they need to think about the people that it's going to affect. So what I normally tell people is you never estate plan for yourself. You estate plan for everybody else that's going to be closing the loops and sort of dealing with the odds and ends. And I don't think anybody really realizes how many loose ends there are until somebody passes away. And then you're faced with all these mailings and, all these things that you're not really sure about what to do with them. So the first thing that I suggest is identifying the people that you need to talk to. Now, a will is different from an advance directive. It's not a healthcare proxy. It's not a living will. It's not a power of attorney. So you don't need to really speak to your medical providers as much as I think people think. I would speak to certain family members. I think it depends on the family, which family members those are, but certainly anybody that you might consider putting in your will, you don't have to speak to them, but I think it's a good idea. And you don't need to go into detail about what you're thinking of putting in the will, but you might want to get a good idea of what the person's circumstances are, and get a sense of how true to the cause they're going to be to follow out any instructions you would leave to them in that kind of instrument. So certainly you'd want to speak to the family. And then you'd want to speak to any financial professionals. If you have an attorney, if it's the go-to attorney that you've used for other matters, you'd certainly want to speak to them about putting the text together. If you have certain investment accounts that don't have beneficiaries, or that you're not sure whether you should put beneficiaries on, you should speak to your accountant, your broker, etc., somebody related to your employer, just to get an idea of how tax sensitive your particular assets are. If you have because that's treated differently in the will when you get to writing it. So if you have any items of value, just take a moment to think about whether it's emotional value, whether it's a family heirloom, or whether it could have any monetary value. You can get something appraised beforehand, so it doesn't need to be done later. So all of those things sort of set the groundwork for you to have an idea of what it is that you want and who it is that you want to administer any property when you see somebody about writing a will.
So that already sounds like so much work. I just want to kill myself. So I mean, can't I just go to zoomlawyer.com or whatever it is, one of these, things, and or write on a napkin and say, give it all to so-and-so and be done with it?
Well, to write a will, you need to know what you have and who you want to give it to. I think that simplifies what I said earlier a lot more. So you need to know what you have, and you need to know that when you're signing your will, you're giving what you have to someone. And that's basically it. How you give it to them and all those other circumstances, that's where all the more detailed work comes in. But that's basically what you want to know. And some people can get away with a very simple will. I am an attorney, so I am not inclined to recommend things like LegalZoom or, iloveyoutodeath.com or Law Depot or any of these things where you have a very generic document that gets generated and I've seen some where you fill in the gaps, you just put the person's name and get it signed. They tend, in my opinion, and I've seen quite a few of them at work, people come in with these last minute wills, they couldn't get to the attorney wasn't doing virtual at the time, or they simply did it because it was cheaper or easier, or they didn't know what they were doing. Plug in your favorite reason, you get some documents where they cause much more trouble then they cause many more issues than they resolve. And then that's a problem because the estate, the will might not stick if there's an issue with it. So that might change how you view your estate plan.
So by
yeah.
not stick, what do you mean?
By not stick is that if the will is not properly executed, many times you print out the document, but because you're not using an attorney, you're using a software, let's just say it's Zoom, LegalZoom, the execution of the will is up to the person in their home. Now, New York is a very traditional state, but it's not alone. I know that people who are not from New York are listening in as well, but wills need to be executed with all the bells and whistles. All your T's need to be crossed and all your I's need to be dotted. So you need to make sure that the language is appropriate, that there's two witnesses, that it's notarized. So it needs to be done just so. If the will is not found valid, no matter what it says in the actual text, the court, whether it's surrogate's court, in New York we call it that, I know other states call it probate court. The court that is in charge of appointing somebody to administer your property, the one that reads the will, they might not necessarily think that the will is valid because it's not properly executed. You're never going to be guaranteed proper execution with any one of these softwares or programs. So that's one way that the will might not stick. If the will is vague because it's not drafted by someone who has the expertise to tailor it to your particular circumstances, then part of the will might stick, and then part of the will that is vague, whatever the intention was there, might get lost. So it's to me, it's a time where if it's someone who really needs a will, and we can go into that subject as well, it's worth getting an attorney who drafts them well, and then you probably don't need to make too many revisions after that.
Okay. Well, actually, let's get into that now. Like, who needs a will?
Sure. So people who need wills, and this is sort of going back to my introduction, I don't think it matters how much money you have. It doesn't matter if your estate is $3 or 3 million. If what you intend, if the plans for your property are different than what would happen under the law naturally, if you did not have a will, then if your plans are different from the default, then get a will. So how do people know what the default is? You would consult with an attorney. If you're going to leave everything to your spouse, you have no kids, well, if you have no will, everything is going to go to your spouse regardless. So how it goes to them, if you have a significant amount of money and you want your spouse not to be taxed, then in that case, even if it were all to go to them, you might want to get a will to sort of avoid that, or consider a trust, or that's, that's a different conversation. But if you have an estate that is not tax sensitive and you want something to go to your spouse, if you pass away intestate, so without a will, it will go to them anyway. Maybe a will is not exactly what you need, and that's all right. Maybe you have assets such as a plain vanilla bank account, or a Roth IRA or something like that, and there's a beneficiary on it. When you pass away, you want your Roth IRA to go to your nephew. So that's fine. The will not trump that. So if you write a will saying that you want that same IRA to go to your niece, that's going to be problematic. It will go to the nephew. So if you want something different from what would happen if you died without a will, then you make sure you get a will, and the language provides for what you want. If you want to leave something to your heirs, but then you also want to include a charity such as Malecare, or any other charity, then you have to make sure that that's provided for in the written instrument, or else it's going to be a problem. Then you're relying on somebody else to make that donation, in your name, and it's a different scenario.
Yeah. And of course, everybody listening in is in fact going to leave something to Malecare. So that is important information. How wealthy do you have to be before tax considerations play in?
You have to be extremely, extremely wealthy. Oh gosh, I don't remember what the guidelines are, but you need to be in the millions and millions. So, and then for that, you'd consult your attorney, your accountant, your broker, your financial squad, and they would make sure that they tailor a document specific, so that people don't get taxed, or get taxed as little as possible when they receive their benefit from the will or their inheritance.
So at that point, a will is more an instrument of avoiding tax or saving tax. What do you think?
It is minimizing tax whenever it's applicable. Mhm.
Yeah. Now, what if I guess a conversation about wills is really a conversation about what ifs, but from the very basic kind of things, like what if you live alone, you are alone, and you're happy with the life you've led or not, but there's nothing going on. You don't have anything of concern after you're gone. What then?
If you don't have anything of concern, then think about what it is that people will need to do to sort of wrap up anything such as maybe you rent an apartment. I mean, in New York City, which is where I am based, most people rent units. Most people do not own. They might own a co-op, but there's renters. But you might want the contents of your apartment to go to somebody. You might want your regular bank account, even if it has $2,000 or whatever else in it, to go to a particular person. So even if you don't have much, it does not really matter. Whatever you want to happen with your little pile or your big pile, you would consider who you want it to go to. And if it's not the next of kin, let's say you don't have spouse or children and your parents predeceased you, as is natural occurrence, do you want it to go to your brothers or sisters? Maybe you're an only child, no siblings, no nieces, nephews. Now, do you want it to go to, whoever's next in line? That would be, maybe an aunt, maybe a grandparent, maybe a cousin. If you're not close to any of your relatives, you might want it to go to a charity or to a third party. So whatever it is that you want to happen, the will gives you some assurance of that. You can't foresee for everything, but if it's well drafted, the court will acknowledge what the intention of the testator, the person whose will it is, and they will try to make sure that it happens in the way that the person desired it. So I think that people really need to consider what they want to happen to their property, regardless of the amount. I also think, given what I do working now and seeing from the court's perspective, that you want to leave behind a clear idea of what your family tree looks like. When a person passes away and they have a will, or they have a relative, or maybe a neighbor that has, took care of them during their illness and was closer to them than any blood relative could possibly ever be. When you pass away and there's someone in that position, that person will go to court, with a will or not, to see what it is that they can do to sort of, make sure that things are taken care of. And the court will always ask them, doesn't matter who the next of kin is of the decedent, who are the natural heirs. So what I think they should do, and I've suggested to people to do this when I had clients, is they should leave, as detailed as possible, a family tree. If anybody predeceased them, to just make an indication that that person was related to you, but they predeceased. That gives whoever goes to the surrogate's court something to work with. It's an idea of who you even have to contact, especially if there's no will.
And when you're saying court, I mean, I just think judge, jury, and audience. Is it a trial of the Chicago 7 kind of scenario, or I mean, what do you walk through the doors of the court building? Then what happens?
Sure. So I think before fully answering it, I'll just preface it by saying that the will, the instrument itself. The will usually names somebody, executor, I think it's usually known as, or personal representative in other states. That's what they're known as. That's the person that the decedent would nominate to handle all of their affairs. They might also be a beneficiary in the will, or they might be the person simply in charge of, giving the charity its amount, or the relatives their amounts, etc. So the idea is that the will is precatory language. So that person is not authorized to administer any property until the court has approved the will, the instrument. And if there is no will, they need to approve a particular proceeding. So when someone walks through, our revolving door at our courthouse, anyway, it's a revolving door, then they might be instructed to my department, to the help center. And then they would tell us, if the person died with or without a will, they should bring it. We need to look at an instrument to see what it is that we're working with. And then depending what the circumstances are, they do a filing. And in not all states, but in many, including mine, which is New York, if the value of an estate is under 50,000, 50,000, then it's considered a small estate for the most part. And if it's over 50,000, it's simply non-small. So if you had a will, it would be a probate proceeding. So someone passes away and you walk to the court to figure out what proceeding you need to file. if any, so you can be properly appointed to administer this decedent's property.
And by court, I mean, I mean, you're an attorney. Is that, I mean, you're not the person who's executing or, friend of the person who's dead. They're not standing in front of a judge. It's just like going to a desk and talking to somebody.
Not necessarily, right. So when you come to the court and you figure out, we tell you what proceeding you need to file, many times you just proceed transactionally. So even that can be challenging sometimes. Obviously, not all estates are created equal. Some require a bit more paper than others. But as long as it doesn't become contested or litigated, then there would really be no reason to see a judge or have a trial or, have to be cross-examined or anything like that. So it's not sort of like a TV trial moment. Things really only go to trial if they become contested, if they become litigated. And many times that can happen if the will is vague. Person reads it to their advantage and the other person reads it to their advantage. And so now the judge needs to decide. So it's important to have a well-written will. But if the will is kosher and everyone's involved on board, or you have all transactionally everything that's required, you never need to see a judge. They'll approve it, you'll see their signature, but you never have to make an appearance.
So before I die, I need to figure out who my family is, make up a family tree thing, perhaps with phone numbers or emails and stuff like that.
Anything you have would be helpful.
Right. And collect account numbers and locations of everything I want to give away and own. And I won't be owning it anymore when I'm dead. I want and things and people such as children. That's also part of what I'm giving away or assigning inside a will.
You mean in terms of if there are minors involved?
Yeah.
So if the minors are your children and you're writing the will, what you can do in a will is you can provide for a guardian. Now, if it's two people that are married, normally the surviving parent would take care of their children if they're theirs. But if you want to leave property to an infant, you can do that. And there's many ways to do it. You can leave it to them outright, or you can say, when the child turns 18, they'll get this much. When they turn 21, they'll get that much. Or, we'll wait until the child is 25 and then they'll get it outright. So that much can certainly be tailored. So to recap what I said, if there's infants involved, you can appoint a guardian for them. You can nominate someone to be a guardian for them in the will. Or if it's a matter of leaving them property, then you can leave them property either outright, either to their guardian, or you can make sure that they get it sort of gradually when they get older.
How do I choose who's going to do all this when I'm gone?
So I think that a person needs to consider who is going to be the most reliable in carrying out their wishes when they're not there. So I think it depends on who's had a presence in their lives up to that point, and who intends on continuing to, who has good management skills. Sometimes a person, because of their best of intentions, they're just either not good at managing money or they're not organized. And estate planning and estate administration and distribution, it's all about being organized and documents and all of that. So someone who is reliable, I think that's first and foremost, because if they don't understand the paperwork, they can hire someone to do the paperwork for them, quite frankly. But, or in most cases they can. So the idea is someone who's reliable, someone who will carry out your wishes and your intentions. And then after that, someone who's organized and can follow through with the paperwork, or have the wherewithal to go get some help, some assistance.
Yeah, and that person actually can get paid in all states, most states, what?
I think all states, but it depends on the value of the estate. So if someone's estate, like I said before, if it's under $50,000, that means it's in the, at least in New York, it's the small estate category, but I know that that's a magic number for several states, then that person, whoever is in charge of the estate under a small estate proceeding, they do not get a commission, they don't get paid. They can get reimbursed for any expenses that they had in relation to the administration of the estate. So for example, if it's a small estate, but you weren't sure what to do about any taxes and they consulted with their accountant and their accountant charged them, well, they could get reimbursed for that expense. If they paid for a funeral or disposition, they can get reimbursed for that, but they don't get a commission. Now, for other estates that are, past a specific value, yes, then the person can get a commission, and it's usually a small percentage.
Yeah. And is a will like a place to like tell people off? Like, like you write down like, dear Fred, now that I'm dead, you're really a douchebag. I don't want to, here's a penny for your thoughts. I mean, does that happen?
Yes, it does happen. You can put in a last will and testament anything as long as it's legal. You can't, can't put something that would promote, any illegal activity. But you can leave someone $1, because they were just so quote unquote great, while you were alive. I've seen that. I've also seen some people simply put down, to my brother, I leave absolutely nothing, for reasons best known to us. So that's still, I think, a bit of a jab, but probably a more discreet one. So they can write it in a will. Personally, I think that causes more issues than it's worth. I don't know if that person would have been a natural heir, then maybe that might leave, an open door for them to come back and contest simply because they're, upset. But yes, you can do that. You can leave a person a penny for their thoughts, $1, just make an affirmative statement that you are knowingly disinheriting them. It's possible, as long as it's not illegal, so you can put it in.
Yeah. But if you put in something for someone else, it's required that they either attend a reading or receive a copy of the will. Is that correct?
You're talking about beneficiaries in a will?
Yeah, yeah.
So whenever the will gets probated or processed by the court usually requires, and it depends on who we're talking about specifically, but when we're talking about natural heirs, people who would have inherited had there been no will, or maybe would have inherited differently had there been no will, they're required to provide consent or a waiver. If they don't, that could turn into a court citation, means a court day. You get your day in court, and then you can either consent on the record or you can, contest it. It might be short-lived, it might not, but that's what happens with people who would be natural heirs. If it's people who receive an inheritance simply because they're a beneficiary or charity or something like that, then they get a notice that the probate proceeding is going on. Best practice is to usually include a copy of the will along with the notice so everybody's on the same page. And then it's usually up to the attorney to really follow up, or to the interested parties to inquire.
Yeah. So, I mean, it sounds complicated and expensive, but I guess it's sort of silly to say, but going through the process saves the people you care about a lot of time and grief, and they're already experiencing grief. So it's a bit of a kindness to have a really well-established, well-written, clear and easy to execute will. Is that fair to say?
I think it's fair to say it doesn't always need to be so expensive. I think the cases that wind up being more expensive are either because the assets were not all included in the will, or somehow the assets were not, they were a bit scattered and the person was not organized, or simply the family does not see eye to eye, those cases become expensive because they become litigated. So if there is an issue with the assets, or if there is an issue with the family, that will be much longer lived, not in the best way. But for people who leave their assets more or less in an organized fashion, and when everybody in the family sees eye to eye and you know where everybody is, there's nobody whose whereabouts are unknown or simply does not want to talk to you, then those cases can proceed in a straightforward manner. It usually costs less to process them. And in some cases, people can do it without the use of an attorney.
Yeah. So before we close this, I mean, like, give us some amusing war stories.
Oh gosh, amusing war stories. I don't know. You mean like in terms of maybe a crazy will that I've seen,
Yeah,
or?
why not? I mean, somebody left somebody a cow or something. I don't know.
Oh gosh. Well, not a cow, but I did read a will once, and the decedent was an actor and apparently loved Shakespeare. And not the entire will, but a fair amount of the will was written in Shakespearean English. Oh God, yes, exactly. It was slightly less funny at the time because I had to make sense of it, and I was sort of asked to make sense of something on the spot. And I'm like, it's like you're asking me to read Hamlet. Like I really don't understand. So for every person that he left someone to, he had sort of like a different paragraph, relating to a different character, and it was written in Shakespearean and English. And I had to tell the person, like, I need more time with this instrument to sort of figure out what it says in normal English so that I can answer your question. I have never seen another will written in Shakespearean.
Oh,
So
well, that's very cool.
it's fine. The will was valid.
Yeah.
So
Actually, that's an interesting question, though. I mean, like, in the United States, must the will be written in English?
yeah, that's what I learned in law school. So yes, certainly. The will should be written in English if it's a will that's drafted in a different country and it goes by their national language and you want to process it here, that's okay. You can always get a certified translation, and usually that's accompanied by documents of the equivalent of the surrogate's court in that different jurisdiction. But if the will is done in the United States for US property, it should be written in English.
Yeah. But I mean, you could imagine that there are people for whom English not only is a second language, but may not be a language at all, and yet have lived here for dozens of years.
What I have done, obviously in New York City, have people that speak many different languages, is there at the very end of the will, you're supposed to have, at least in New York, an attestation for the witnesses. And that has, a fairly standard, already pre-accepted, we know it works, language. You put certain language in that attestation. And there you make all the disclaimers and cover all your bases. So if the person is a Spanish speaker, Mandarin speaker, which those are the two most common that you have in Manhattan, at least, you would put that even though the person cannot read in English, the will was translated and read to them in their native language of, insert the language, and that the person was fully informed and was of sound mind and memory when they did it. I have executed wills for people that are blind and they cannot read it. The will is not in Braille. And I have put in the attestation clause, although, this person suffers from blindness or is blind as of etc. or legally blind, the will was read to them. They understand it. They're over 18. So they can sign a will that will be considered valid by the court regardless.
Yeah, very interesting. It's actually, I mean, at first glance, it sounds mundane, but it actually seems extraordinarily interesting. So well done. Erica, thank you very much for taking time for this helpful conversation. Welcome to the conference, and please continue to be a resource to Malecare.
Yes, with pleasure. Thank you.